What if the next generation of worker rights is not just about minimum wage, overtime, termination pay, or discrimination? What if future employees need a completely new category of rights, namely, AI rights? Not because AI is evil, but because employment law was built for a workplace where humans made the decisions. A human hired you. A human managed you. A human evaluated you. A human disciplined you. A human terminated you. But what happens when those decisions are increasingly influenced by systems you cannot see, cannot question, and may not even know exist? That is the problem, because the future workplace may still look human on the surface. There may still be a manager. There may still be HR. There may still be a performance review. There may still be a termination meeting. But underneath all of that, AI may have already shaped the outcome. And that is why future employees may need AI rights. Not someday in a sci-fi future. Sooner than most people think. The first AI right may be simple, the right to know. If AI is being used to screen your resume, rank your performance, monitor your productivity, recommend promotion decisions, flag you as risky, or influence discipline, you should know. Because you cannot challenge a system you do not even know exists. This is already becoming part of serious regulation. The EU AI Act treats many AI systems used in recruitment, hiring, and worker management as high risk. It also requires deployers of high-risk AI systems to inform workers before those systems are used in the workplace. And that matters, because the first problem with AI at work is not always bias. Sometimes the first problem is invisibility. You may be rejected, ranked lower, monitored differently, flagged internally, denied an opportunity, and never know that AI played a role. So the first right is, you should know when AI is involved. The second AI right may be the right to explanation. Not a 200-page technical document, not source code, but a meaningful explanation. What data was used? What factors mattered? Was this based on productivity, communication patterns, past performance, predicted risk, comparison with other employees? Because if AI affects your job, your pay, your promotion, or your termination, the system said so cannot be enough. The problem is that current legal protections can leave gaps. For example, GDPR Article 22 deals with decisions based solely on automated processing that produce legal or similarly significant effects. But many workplace decisions may not be solely automated if a human gives final approval. And that creates the dangerous middle zone. A human signs off, but the AI shaped the decision. So was it really human judgment? Or was it algorithmic judgment with a human signature? That brings us to the third right. The right to real human review. Not fake human review. Not rubber stamping. Not a manager clicking approve because the dashboard looks convincing. Real review. A person who understands the context. By a person who can question the system. By a person who can look at the worker's explanation. Because if AI says someone is underperforming, there may be reasons the system cannot understand. Maybe the person handled harder cases. Maybe another team caused delays. Maybe the worker had an accommodation need. Maybe the output was lower because the work was more complex. Maybe the system measured speed but ignored quality. This is where workers need protection. Because AI may be very good at measuring what is visible. But some of the most important things in work are not easily visible. Judgment, mentorship, creativity, emotional intelligence, crisis handling, strategic patience, quiet problem solving. So if AI is used at work, employees may need a right to say, wait, the system is missing context. The fourth AI right may be the right to challenge the data. Because AI systems are only as good as the data underneath them. And workplace data can be messy, incomplete, misleading, or unfair. Imagine a system says you are less productive because your response time is slower. But maybe you are doing deeper work. Imagine a system says you collaborate less because you send fewer messages. But maybe you solve problems without creating noise. Imagine a system flags you as less engaged because you do not speak much in meetings. But maybe you are neurodivergent, introverted, or simply working in a different style. If workers cannot challenge the data, then the system's version of reality becomes the employer's version of reality. And that is dangerous. The fifth AI right may be the right against AI discrimination. This is huge. Because AI discrimination may be harder to see than human discrimination. A human manager may say something discriminatory. There may be emails, comments, patterns, witnesses. But AI discrimination may hide inside data, correlations, proxies, and model outputs. The system may never ask about race, age, disability, gender, pregnancy, or family status. But it may still use patterns that indirectly disadvantage certain groups. That is what makes it so hard. The discrimination may not look like discrimination. It may look like a score, a ranking, a prediction, a fit assessment, a performance risk. And if workers do not understand how the system works, how do they prove what happened? This is why AI could make employment discrimination harder to detect and harder to challenge. The sixth AI right may be the right against excessive surveillance. Because AI does not only evaluate work, it can evaluate behavior, keystrokes activity levels, communication patterns, meeting participation, tone, sentiment, response speed, location, workflow habits, and potentially much more. The OECD has already identified algorithmic management as systems used to instruct, monitor, and evaluate workers. Its employer survey covered over 6,000 managers across 6 countries. This is where privacy becomes a worker rights issue, because employment is not equal consent. If your employer says this system is part of work, how much choice do you really have? So future employees may need rights around what can be monitored, what cannot be monitored, how long data is kept, who can access it, whether emotional or psychological analysis is allowed, and whether surveillance continues outside actual working time. Because without limits, AI could create the most invasive workplace in history. The seventh AI right may be the right to consultation before AI is introduced. This is especially important for unions and workplaces with worker representation, because AI deployment is not just a technology decision. It can change workload, performance standards, job security, privacy, promotion pathways, discipline, even workplace culture. So employees may need a right to be consulted before high-impact AI systems are introduced. The UK Trades Union Congress has proposed an artificial intelligence regulation and employment rights bill focused on AI use affecting workers, employees, and job seekers. That matters because labour groups are beginning to understand that AI is not only an efficiency tool, it is a power tool. And if AI changes power inside the workplace, workers should not be the last people to know. The eighth AI right may be protection from AI-based dismissal. This may become one of the most important rights, because being fired is not just an administrative event. It affects income, housing, immigration status for some people, mental health, family stability, career reputation. So if AI influences termination, restructuring, redundancy selection, or performance dismissal, there should be stronger protections. A worker should not lose their job because a system labeled them inefficient, replaceable, risky, or low value without real human review and meaningful explanation. This is where future employment law may need to say clearly, AI can assist, but AI cannot become the hidden judge of a worker's livelihood. And the ninth AI right may be the right to dignity. This one sounds abstract, but it may become the most human right of all. Because if workers are constantly measured, ranked, monitored, predicted, and optimized, people may start behaving for the system, writing for the system, replying for the system, appearing productive for the system. And eventually, the workplace may reward the person who is easiest to measure, not necessarily the person who thinks most deeply. So future AI rights may not only be about data. They may be about preserving human dignity inside increasingly automated workplaces. Because the future workplace may still have humans in charge on paper. But the real question is, will workers have rights when the power behind the decision is no longer fully human? That may be one of the biggest worker rights questions of the AI era.